Welcome. If you are watching this video, chances are you are going through one of the most painful experiences a parent can face, not knowing where your child is or being separated from them across international borders. First, know that you are not alone, and there is legal help available. Today we are talking about international child abduction and custody disputes involving Brazil, and specifically about how the law firm Botinha and Cabral can help you navigate this incredibly complex and emotionally charged legal landscape. Whether your child has been taken to Brazil without your consent, or a visit turned into a permanent stay, every single day matters. The decisions you make right now, and the legal team you choose, can determine the outcome of your case. This video will walk you through everything you need to know, starting with the foundation, the Hague Convention itself. Before diving into the legal process, it is important to understand what the Hague Convention actually is and why it matters. The 1980 Hague Convention on the Civil Aspects of International Child Abduction is an international treaty designed to protect children from the harmful effects of wrongful removal or retention across international borders. Its core purpose is to ensure that custody arrangements established in one country are respected globally. Today, over 100 countries are signatories to this treaty, making it one of the most widely adopted international family law instruments in the world. Brazil officially became a signatory in 2001, incorporating the convention into its domestic legal framework. This means that Brazilian courts are legally obligated to recognize and process Hague Convention applications. For families caught in cross-border custody disputes involving Brazil, this is critically important. It means there is a formal, internationally recognized legal pathway available to you, and that pathway begins the moment you take action. Now that you understand what the Hague Convention is, let's talk about what it actually aims to do, because this is where many parents get confused. The core objective of the Hague Convention is straightforward: to ensure the prompt return of a child who has been wrongfully removed from or wrongfully retained outside of their country of habitual residence. In simple terms, if a child was living in the United States and then was taken to Brazil without the other parent's consent, the convention demands that child be returned to the United States. But here is something critically important to understand. The Hague Convention is not a custody battle. It does not decide who is the better parent or who should have legal guardianship. Its sole purpose is to restore the status quo, to put things back the way they were before the wrongful removal occurred, so that the appropriate court in the child's home country can then make proper custody decisions. Now that we understand what the Hague Convention aims to achieve, So let's look at how these situations actually unfold in real life. The most common scenario we see involves one parent relocating a child to Brazil without the other parent's knowledge or consent. This often happens during periods of relationship breakdown, where one parent, typically a Brazilian national, decides to return home with the child, believing they are simply going back to family. Another frequent situation involves agreed temporary visits. A child travels to Brazil with one parent for a holiday or family event, but that parent then refuses to return the child when the agreed period ends. There are also cases where parents share custody across borders and one parent simply stops complying with the arrangement. Each of these situations, while different in circumstance, represents a wrongful removal or retention under the Hague Convention, and legal action can be taken. While initiating a Hague Convention application through your home country's central authority is a legitimate and necessary first step, it is critical that you understand what that process does and does not guarantee. Starting the administrative pipeline does not mean that a lawsuit will actually be filed in Brazilian federal court on your behalf, and it certainly does not mean it will be filed quickly. The Brazilian administrative body responsible for taking care of your case to court has discretion in how it handles your application, and there is no binding obligation ensuring they will pursue litigation nor pursue it aggressively. More troubling still, the administrative bodies involved in this process are not exclusively your advocates. They are government institutions with their own legal interpretations, and if they assess the circumstances of the case in a way that favors the abducting parent, they can and have shifted their position accordingly, effectively defending the very person who took your child. This is not a hypothetical concern. There are documented cases in Brazil where the administrative process changed course midway, leaving the left-behind parent without institutional support at the exact moment they needed it most. Understanding this reality is not meant to discourage you from using the Hague process, but to make clear that relying solely on administrative bodies to carry your case forward is a risk you cannot afford to take. When it comes to Hague Convention cases in Brazil, time is not just important, it is everything. The convention establishes a 6-week guideline within which courts are expected to resolve return applications. This is an aggressive timeline designed to minimize the trauma of prolonged separation and prevent the child from becoming deeply rooted in a new environment. However, the reality inside the Brazilian judicial system can be quite different. Court backlogs, procedural requirements, and the complexity of cross-border documentation can stretch cases well beyond that 6-week window. This is precisely why acting immediately is so critical. Every day that passes without legal action gives the abducting parent more time to establish new routines, enroll the child in school, and build arguments that the child is now settled in Brazil. Delays can seriously weaken your case. The moment you realize your child has been wrongfully taken or retained in Brazil, contacting a specialized attorney must be your very first step. Now, it is important to understand that the parent who brought the child to Brazil will not simply accept a return order without a fight. Brazilian courts allow the abducting parent to raise specific defenses under the Hague Convention, and these exceptions are taken seriously. The most commonly raised defense is grave risk of harm. This means the returning parent must argue that sending the child back would expose them to physical or psychological danger. Courts examine this carefully, but it is often misused as a delay tactic. Another defense involves the child's own objection. If the child is considered of sufficient age and maturity, typically around 12 years or older, Brazilian judges may consider their wishes. Finally, if more than 1 year has passed since the abduction and the child has become settled in their new environment in Brazil, courts may deny the return order entirely. This is why acting immediately is absolutely critical. When navigating an international parental abduction case, it is absolutely critical to address the adjacent legal issues that often arise alongside the abduction itself. In Brazil, parental alienation is recognized as illegal under the Lei da Alienação Parental, and if the abducting parent is engaging in behavior designed to damage your child's relationship with you, this can and should be documented and raised before the Brazilian courts. Similarly, it is not uncommon for the abducting parent to file their own custody or child support claims within the Brazilian legal system in an attempt to establish local jurisdiction and legitimacy over the situation. These filings must be taken seriously and responded to promptly, as ignoring them can have lasting consequences on your case. Above all, it cannot be stressed enough how important it is to seek qualified legal advice before taking any action, whether here at home or in Brazil. Well-intentioned but uninformed decisions, such as making public statements, traveling to Brazil unadvised, or engaging directly with the abducting parent without legal guidance, can irreversibly harm your position in both jurisdictions. Every step you take from this point forward should be deliberate, informed, and guided by professionals who understand the full complexity of international family law. It is also crucial to recognize that when the situation escalates into the criminal arena, whether through the left-behind parent attempting to file criminal charges related to the abduction itself, or the taking parent leveling serious accusations against the left-behind parent, these matters must be treated with the utmost gravity and seriousness. Criminal allegations, regardless of which direction they are aimed, carry significant legal consequences and can dramatically alter the course of the case. The left-behind parent may find themselves not only fighting to recover their child, but also having to defend against potentially fabricated or exaggerated criminal claims made by the taking parent. Similarly, the abduction itself may give rise to criminal charges against the taking parent. In either scenario, it is absolutely essential that competent criminal legal counsel is engaged immediately, and even better before any action. As these proceedings operate under an entirely different set of rules and standards than civil family law matters, and the stakes involved could not be higher. When your child's future is at stake, having the right legal representation is not optional. It is everything. Hague Convention cases in Brazil are extraordinarily complex. They sit at the intersection of international treaty law, Brazilian federal procedure, and family court litigation. A general practice attorney simply cannot navigate that terrain effectively. A specialized Hague Convention lawyer in Brazil brings something irreplaceable to your case: deep familiarity with how Brazilian courts actually operate. They understand the procedural nuances, the judicial temperament, and the strategic arguments that resonate with Brazilian judges. Local expertise also means knowing how to counter the defenses we discussed earlier before they gain traction in court. Timing your filings correctly, presenting compelling evidence, and anticipating opposing arguments can dramatically shift outcomes. Beyond courtroom strategy, a specialized lawyer serves as your translator, not just linguistically, but culturally and legally, bridging the gap between your home country's legal expectations and Brazil's judicial reality. When it comes to Hague Convention cases in Brazil, having the right legal team by your side can make all the difference. Botinha Cabral is a Brazilian law firm with extensive, hands-on experience handling international child abduction and cross-border custody disputes specifically within the Brazilian legal system. What sets them apart is their bilingual capability in Portuguese and English, allowing them to communicate seamlessly with foreign parents, international attorneys, and central authorities across different countries. This eliminates misunderstandings and keeps every party informed throughout the process. Their team has represented successfully clients from the United States, Europe, and beyond, giving them a deep understanding of the cultural and legal complexities that arise in international family law disputes. Botinha and Cabral combine local Brazilian legal knowledge with a genuinely international perspective, making them uniquely equipped to advocate effectively for parents navigating one of the most emotionally and legally challenging situations imaginable. It is also worth noting that both Botinha and Cabral understand the conciliation process as extremely important in such scenario, as every family case must include a genuine and structured attempt at reaching an amicable resolution before proceeding further. We firmly believe that conciliation is not merely a formality but a meaningful opportunity to preserve relationships and find common ground, particularly when children and shared family interests are involved. Our team actively advises parents on how to approach these sessions constructively, helping them understand the importance of open communication, emotional preparation, and realistic expectations going into the process. We guide our clients on how to present their concerns clearly and respectfully, how to listen actively to the other party, and how to remain focused on the best interests of the family as a whole. Beyond advisory support, Botinha and Cabral can also engage directly in the conciliation process, representing and accompanying our clients throughout these sessions to ensure their voices are heard and their rights are fully protected. Whether the goal is to reach a full agreement or simply to narrow the points of dispute, our direct involvement ensures that the process is handled with the professionalism, sensitivity, and care that every family matter deserves. When facing an international child abduction case, having a legal team that walks beside you every step of the way is absolutely essential. Botinha and Cabral provide comprehensive support from the very first moment you reach out to them. It begins with an initial consultation where attorneys carefully evaluate your specific situation, review available documentation, and outline the most effective legal strategy for your case. From there, the firm handles all petition drafting and filing directly with Brazilian courts, ensuring every document meets the strict procedural requirements that Brazilian judges expect. Throughout the litigation process, Botinha and Cabral actively represent clients in hearings, presenting compelling arguments for the child's return. Equally important, the firm maintains consistent communication with your international legal team, foreign central authorities, and Senegius, ensuring all parties remain aligned. Their bilingual capabilities eliminate language barriers, giving you clarity and confidence throughout one of the most difficult experiences any parent can face. Many foreign parents come to us with the same pressing questions, and we want to address them directly. First, how long does the process take? While the convention recommends resolution within 6 weeks, Brazilian court proceedings often extend several months depending on complexity and court schedules. Regarding evidence, you will need documentation proving the child's habitual residence, your parental rights, and the wrongful removal or retention. This includes birth certificates, custody orders, school records, and proof of your relationship with the child. As for traveling to Brazil, it is not always required. Botinha and Cabral can represent you remotely, though certain hearings may benefit from your presence. Finally, if the Brazilian court rules against return, options remain available. You can appeal the decision or pursue alternative legal remedies. Every ruling can be challenged, and our team will guide you through every possible avenue to protect your parental rights. One of the most critical steps a left-behind parent must take during the Hague Convention process is securing a consistent and enforceable visitation schedule, and this should be pursued as early as possible. Whether the child has been wrongfully retained in Brazil or any other signatory country, maintaining a meaningful parent-child relationship throughout the legal proceedings is essential, not only for the child's emotional well-being, but also for the left-behind parents standing in the case. This means actively seeking both in-person, presential visitation arrangements, where the left-behind parent can physically travel to be with the child, as well as virtual attendance options such as regular video calls, messaging, and online communication platforms. Brazilian courts are receptive to establishing these interim contact arrangements while the return petition is being processed. It is strongly advised that the left-behind parent documents every interaction, every denied attempt at contact, and every successful visit. as this record can prove invaluable in legal proceedings. Do not allow geographical distance or legal complexity to become a barrier to maintaining your bond with your child. Proactive engagement with visitation rights sends a powerful message to the courts about your commitment as a parent. If your child has been wrongfully taken to or retained in Brazil, every single day matters. Time is not on your side in Hague Convention cases, and waiting even a few weeks can seriously impact the outcome of your case. You do not have to face this alone. Botinha and Cabral are experienced, compassionate, and ready to fight for you and your child. They understand the emotional devastation you are going through, and they have the legal expertise to navigate the Brazilian court system on your behalf. Do not wait, do not hesitate. Reach out to Botinha and Cabral right now. Visit lawyerinbrazil.com to learn more about their services, read about their experience, and schedule your confidential consultation today. Your child deserves to come home. The right legal team can make that happen. Contact Botinha and Cabral immediately because when it comes to your child, there is no time to waste.